FLSA is the Fair Labor Standards Act. It establishes a minimum wage, overtime pay, record keeping, and other standards for employment, including youth employment, disabled workers, and it applies to employees in the private sector. It also applies to employees in federal, state, and local government. So the FLSA has a section that permits employers to request a specialized certificate. And if an employer gets that certificate, then they are permitted under certain circumstances to pay some disabled workers sub-minimum wage. And the way that works is the employer has to go through a process with the Department of Labor to get the certificate. And then in order to pay a disabled worker less than an abled worker, the employer has to evaluate the productivity of that employee versus disabled workers as a whole. And under the certificate, the only way that you can legally pay a disabled worker less than someone who is not disabled is if you can establish that their productivity is lower than another worker, an experienced worker in the same environment doing the same job. And the pay is determined based on that productivity. It needs to be reevaluated on a regular basis, and it needs to be increased when the experienced worker's pay is increased. So it is a portion of what the quote experienced non-disabled worker makes. This law, when it was enacted back in 1938, the intent was, at the time during the New Deal, was to get companies to hire more people, and specifically to hire disabled workers. The idea, may have been a positive one, to try to encourage employment of disabled workers. But since then, bad actors have really taken advantage of this certificate, and there is a wide-ranging history of exploiting disabled workers through this certificate. The other important thing to note about this exception to the minimum wage laws in the FLSA is that there are certain exceptions. Federal contractors, employees that are working on certain federal contracts, have a minimum wage that is above the minimum wage under the FLSA. The minimum wage previously was $10 an hour and 10 cents for federal contractors. And importantly, under the executive orders that implement this minimum wage, disabled workers are included, and you cannot pay a disabled worker working under the certain federal contracts less than that minimum wage. That was also increased for certain employees, federal contractor employees, to $15 an hour by President Biden in an executive order last year. And again, this includes disabled workers. So some disabled workers are immune from this. The other thing to note is that under the Americans with Disabilities Act, if a disabled worker can perform the same job as another worker with an accommodation, a reasonable accommodation, then that worker cannot be discriminated against because of that disability. The ADA was enacted on July 26, 1990, and was later amended in the early 2000s, but is significantly in the same spot as it was in terms of discrimination against disabled employees today as it was in 1990. So although when the ADA came into play, it didn't change the way that this certificate affects disabled workers, because it's sort of a carve out for employees that are able to do the same jobs with an accommodation, versus under the certificate, and the FLSA requires that an employer show that the employee is less productive, and that is how they are able to pay disabled workers less. When a disabled worker is being paid sub-minimum wage for a job based on their productivity, they aren't per se being given an accommodation. Their disability and how that affects their ability to do the specific work that they are doing affects their payment. The idea being that an employee who comes and is disabled in some way that slows them down, and this is usually in the situation of factory type jobs or doing repeated tasks, right? Fitting something to a pipe or putting a box together. The employee has to be able to do that job. But if as an experienced worker, I could produce 30 an hour, but as a disabled worker, I come in and I'm doing 10 an hour, then I could presumably get a third of the pay of the person doing 30 an hour. An employee asking for reasonable accommodations should speak with their medical provider about how their disability is affecting their work performance. And then they should reach out to their HR department, their supervisor, or whoever else is provided, their compliance officer, to discuss what accommodations they need and have an open discussion with their employer about how they can get the accommodations they need to do the job. And anyone with concerns about this, anyone who's getting pushback, should definitely reach out to a lawyer to help them work through that, because there are so many complications with getting the right accommodation for you, and it's something you need to work with your medical provider and your employer. And if you're having trouble with that, a lawyer can really help you navigate that in a way that will be beneficial to your future employment. It's important to know that President Biden has announced that he is proposing to revoke this certificate, allowing employers to pay disabled workers sub-minimum wages, but we haven't seen any, direct movement on that. There does appear to be bipartisan support in Congress to do so, but no movement as of now. South Carolina, however, recently became the 14th state to ban the use of these certificates in a state. So Governor McMaster signed the legislation into law on May 24th of 2022, and the legislation bars employers from participating in the 14C waiver program under the FLSA. The new law requires that programs under this certificate end by August 1st, 2024, meaning he is phasing it out versus cutting it off. So there is a time period for the next 2 years where we're going to see employers, learning how to phase this out. Employers in South Carolina who are currently operating under the certificate, the 14C certificate under the FLSA, should make a plan for their workers to get them up to minimum wage at the very least, and to ensure that they aren't discriminating against the disabled workers moving forward. They should also have a plan in place for ensuring that workers are going to continue to get the same benefits that other workers are getting on the same level. I think that South Carolina's enactment of this legislation is a hopeful sign that a lot of states are getting on board. There certainly does appear to be some bipartisan support in Congress for this to make a change on the federal level, but there does seem to be a trend lately of states sort of stepping in to take this over. And South Carolina doing that is certainly a sign of that bipartisan support. As South Carolina and other states coming before South Carolina, and hopefully other states after, are phasing out of this, that this is going to affect some of these disabled workers in big ways. It may affect their ability to find employment, and it also may affect how they can receive federal benefits. Certain benefits require that employees make under a certain income, and so it will affect their ability to get benefits if they are paid more, and really may change the landscape for disabled workers in those states and potentially eventually throughout the U.S. So it's important as this moves forward that we all think about ways to have an informed phase out of these systems to make sure that disabled workers are getting the support that they need, and that we are continuing to encourage and require that disabled workers get the same treatment as other workers throughout the U.S.